We'll share it.
So we'll give you an extra. We have a copy.
Sorry. Yes.
So as far as government of West Bengal is concerned, just please go around the 8th to the 9th column. You will find 52. And the corresponding date is 1/1/2013. Your Lordship has 52 as the rate of DA percentage.
30.
30 and 1/1/2013. And that's 52.
Yes.
If you go down to Government of India, please go down to the figure 80.
30.
And the corresponding is 1/1/2013. Correct? So just going back to the note which I was placing, if you go to point 15,
Yes.
an illustration of the dearness allowance component of a state government employee with an existing basic pay of 50,000 as on 1st April 2008. As on 1/1/2013, the dearness allowance applying the 52% would be 26,000. For us, as this is what we are paying. But applying the directions of the tribunal to calculate the DA on the basis of, now they say that you must go on the basis of AICPI, number published from time to time, would mean that as on 1st January 2013, the DA computation would be as follows, which would be 80%, which is 40,000 rupees. The Lordship has that. So that's now point 17. Please just have a look at point 17 in my note.
Yes.
The central government derives the percentage of dearness allowance immediately on the basis of and in response to the average AICPI index as published from time to time. The tribunal records also that for the central government, DA percentage increase will be the same percentage increase in AICPI, and that is paragraph 28.5, page 480 of volume 2. In substance and effect, in substance and effect, the dearness allowance percentage published by the central government is linked to and determined on the basis of the AICPI average as published from time to time. So that's the central government formula. Despite, sorry.
Just First, one is still on his legs. But how do we read that? You take it that we have not read the June judgment. You take it that we have only read para 33 of the CAT judgment. How do we read this principle of ASPI into ROPA? Is something which you have to explain.
Shall I not write
No, not
in any time?
Just keep that in. Because that is one thing. See, primarily when we started, we were concerned about more of the constitutional aspect, that is 21. In all fairness, all of you said that 21 does not apply when it comes to DA. Now we are into the nitty-gritties of whether what is going to be the DA, percentage of DA. Now, more or less on that, to begin with, we were convinced that yes, the High Court perhaps is correct. But having Mr. Dewan having taken us only to this limited submission, we are putting it to you. Just keep that in. That's.
I can indicate the answer. There's no great secret at all, Lord, about what should be the, as my Lord Justice
if you don't mind, please.
asked, what is the list between the parties?
Yes, of course.
Lord, the list between the parties is, my friend says that what is the rule that is 3C3, according to him, it is a static, stratified, fossilized AICP index.
Correct.
According to us, my Lord, the word index itself means it is mobile with passage of time. That is all.
Where do you get that from?
From the rule itself and from the pay commission, Well, in fact, what is important is
All these years.
the Pay Commission, that is the West Bengal Pay Commission, actually said that you, the state government of West Bengal, from 1979, from times ago, have always kept in mind the AI-CPI index. But you, in fact, defrayed all these dearness allowance payments with considerable delay. But why don't you do one thing? Bring yourself up to date when you make the new ROPA in terms of our Commission's recommendations, and then be in line with AI-CPI.
But from ROPA,
Yes.
whether the recommendations are binding or not, statutory or not, that's a different matter.
Yes.
But ROPA,
ROPA will not signifies that.
where can you just
Yes, straight away.
straight
Well,
away?
that, in fact, that was the most critical question which my Lord Justice Mishra asked about the 3C. And that is one of the heart of this matter. Please take the rule between you.
We have it.
Yes. Please take the clauses of 3C.
Page 127 of
That's right. Please have a look at this. My Lord, existing emoluments
in the aggregate of
means the aggregate of existing basic pay. That's the first.
correct.
The second is dearness pay appropriate to the basic pay. So, my Lord, what happens is when a revision of pay happens, there is a merger of the basic pay and the dearness allowance which existed as on the date. That is merged. And then we come to 3. 3 is important. Dearness allowance appropriate to the basic pay plus dearness pay. That is, my Lord, Roman 1 and Roman 2. My Lord, what Roman 3 says is, how will you calculate DA? That is, what was till now basic pay. You add the dearness allowance and merge it. So it is Roman 1 plus Roman 2. On Roman 1 plus Roman 2, Roman 3 will be appropriate to the basic pay plus dearness pay. Now, the crucial word is at index average. 536 within brackets. 1982
But
is equal to
index
100.
average is defined there.
Well, index
It's
average.
not left open.
No, but if it's not left, that is the point. If it is index average, when you use the word index, it itself suggests that there will be a mobility because the factor is given within the parentheses. Now, what your lordship sees 536 within brackets, 1982 is equal to 100, shows that 1982 is equal to 100 was updated in the year 2005, which is 536. So, my lord, it falls and follows the index. So, now what my friend, and my lord, very astutely, if I may say so, because it's not really reflected in the judgments, is about this. Well, the point which was argued was, you have no rights, you have no rights. But this is a very astute point. Namely, it is stratified. That is, it is frozen in ROPA. And after that date, the index cannot move. Well, that's the contention. According to us, well, the very word index suggests mobility. And that is how this whole India consumer price, and in fact, well, in that 2-page note which my learned Mr. Divan gave, please see item 11. That is enough for me, Lord. Item para 11 of this 2-page note. Please see para 11. The AI-CPI index rates are alien to the ROPA 2009. Now, we'll not see the next few words. Say and except only for the definition of a component of existing emoluments in 3.1c3. So, my lord, AI-CPI is not alien for 3.1c3. And AI-CPI, my lord, index. The word index is most vital, my lord. Index means it is a discoverable value from time to time.
It's base, that is the base.
This is one of the lists.
So, but as per this chart, which
Yes.
they are showing, the index, this index average is very
Varying from
increasing
year
from
to
time
year.
to time.
Yes, yes.
And it's
According
been
to
down
them
to
also, it's
526.
not static.
Yeah, exactly. my lord.
The
So
only
which is
thing,
that index which you will take into account? That is AIC. Sorry.
Adding to what my lord is saying.
Please, my lord.
See, 536 as per this chart is the value, average
In
value.
2005.
2005.
Correct, Manoj?
ROPA comes into picture.
It comes in, no, I'll take it.
2009.
I'm grateful. Let me explain this. Well, that figure of 536, that is 1982 is equal to 100, is for the year 2005 because well, the Central Pay Commission revised the pay with effect from from 2006. 1st of January 2006. That is why this 536 becomes relevant. What the West Bengal Pay Commission said is, follow that same index because you have followed it from 79, and as on the date of the application of the rules, they said it will be linked to AICPI. And our rules came later, that is because the Pay Commission was set up later. That's the State Pay Commission. But really the crux is whether it is index.
So whether it is static or not, that is the
real. That is the new point, the novel point.
This 536 was arrived on the basis of AICPI.
AICPI. That is the point. The 536 is AICPI.
AICPI as on 1/1/2000.
just a minute.
AICPI as on 1.
Calculation of future increase in DA on the basis of AICPI.
Precisely. In fact, according to us, it's embedded. In fact, that indication of the figure 536 within brackets 1982 is equal to 100 clearly shows that the index of 1982 was being updated up to 1st of January 2006. So, the principle is that if you go by that indexation, then naturally, as and when this discovery of AICPI is done by the Bureau of Labour, that's one of the Labour Ministry, with the Ministry of Consumer Affairs, that is they've taken all India weighted average of what is called basket of goods and services, where there is an increase. And it is that inflation.
From ROPA.
Yes.
Can we make out anywhere from ROPA? Anywhere else in ROPA?
Yes, I can show from the evidence in ROPA itself.
No, what we have seen.
Yes.
Reading of ROPA.
Yes.
Somewhere, anywhere else other than to see.
So these two words are crucial. The use
Mr. Padwali, just one.
words.
We will allow each one of you. What I told you. We are trying to understand. We are not finished. We are not concluded. He still is on his legs. As and when some queries come to us, there are two ways of proceeding. Either we keep quiet, hear them, hear you, and
I was responding in that.
as and when doubts would come to our mind, we would pose queries.
So very good, Manoj. I'm only responding to that.
Just one.
And if we keep quiet, there will be some constitutional interjection in between.
So the doubt has come in our mind as to whether this is static or not. So one has used the word static. Now, how do we say it is not static? Because the figure is given there. From ROPA, can we make out that yes, it is not static? Is what we are asking.
Well,
Not from the definition clause.
Very well, my lord. Would your lordship kindly see Roman 3 with me?
We've seen.
Dearness allowance. Can your lordship kindly see the next word?
Appropriate to the basic law.
Appropriate. Now, what does the word appropriate mean? Appropriate to the basic pay plus dearness pay, that is Roman 1 plus Roman 2, at index average 536, 1982 is equal to 100. So, my lord, it says that dearness allowance will be calculated on the basis of this index average. It is not indexation. And indexation is always a mobile figure based on the realities. And that is at index average. And the two words, index average.
It could have said index average as on today, which is.
Well, it is as on, in fact.
It doesn't say that.
No,
we are not the legislators. We are not.
No, I understand. There's no problem.
We are just, thinking a lot.
Of course.
It doesn't say.
Yes.
Fixes. It doesn't say as on.
There's another, there's another rule.
Well, how do we read a statute? That's what we are.
No, I understand. And that is why, my lord, when you see these words, that is dearness allowance appropriate. How do you get appropriateness? By using that indexation. That indexation, my lord, in the very nature of things, is mobile. That is the point. That index, the word index itself means mobility.
Other than this.
Other than this, there are two other places in these set of rules where you will find.
Please, can you
Yes, please. If your lordships will kindly.
If you don't mind. Just
No, please.
Please just see, Manoj, for a moment. If your lordships will be good enough to see rule 7.
Fixation, we've seen this.
Yes, rule 7. Fixation of pay in the revised pay structure. The initial pay of a government so-and-so will be governed and formed from first day shall unless so-and-so otherwise be fixed separately in respect of his substantive pay and so on. And then your lordships will find, if you come to the proviso note, the one above note 1.
Yes.
Provided the pre-revised dearness allowance appropriate to the existing non-practicing allowance admissible at index average of 536, 1982 is equal to 100 shall be added while fixing the pay in the revised pay band and the amount of non-practicing allowance at the rate so and so. So, Manoj, as on the date of revision of pay, you actually employ this formula of indexation. That is to Roman 1 plus Roman 2, you add this index formula. But that index formula means that as and when it changes from 536 and it goes elsewhere in that sliding scale which was shown, then Manoj, it adjusts itself. So Manoj, really the rule is one for adjustment in a pay band. Manoj, in a pay band, there's an adjustment. Okay. This is the point. But I must say, Manoj, it's a brilliant point taken for the first time. I have no objection. The point is a good one. It should be dealt with.
Just 1 minute to add, with your lordship's kind permission.
Yes.
Please see the same definition, dearness allowance again. Your lordship said, where does the indexation come in? Indexation comes in by the use of one expression and some words. It says dearness allowance appropriate at the basic pay plus pay at index average. Index average is a well-known expression, as Mr. Diwan's note number 3 and 4 points, it showed to your lordships that this index average is given by the Labour Bureau twice a year on 1st January and 1st June. I'll just read point number 2 and 3 which he has said. This index average is published by Labour Bureau, point 3. The Labour Bureau revises the index average twice a year on 1st January and 1st June. The broad purpose of this index is to enable adjustments with respect to inflation. Therefore, dearness allowance, as we all know, has two components. dearness allowance appropriate to basic pay, which is fixed when the pay revision takes place by the pay commission. And the second component of dearness allowance is dearness pay. Dearness pay is never fixed. It is always linked to inflation, which is consumer price index. So therefore, your lordship may see the plus dearness pay at index average, and we know index average comes twice a year. And why should it slide? The next 82 equal to 100 has to be given some meaning. If 1982 is equal to 100, when I'm getting pay in 2010, we will have to see this 100 also, what it is. So therefore, this 82 equal to 100 is very crucial. So the rule tells us when you are fixing dearness pay on the indexed average, you will take 1982 as 100. Then what do? You see the index average for that year and give the dearness pay. Now, therefore, 82 equal to 100 is very crucial when your lordship actually sits down to interpret the rules.
See, you want us to read into
No,
add something to the statute. Anyhow,
No,
we look into it.
index. Now two more points. Number one, the proof of the pudding is in the eating. On index average, they have been giving it to us. They have been giving it, but they have not been giving it twice a year. So what was our problem? Our problem was we went to the CAT-C. They are giving it, but they give it whenever they.
We'll come back to you.
Yes.
Continue, Mr.
Great. Now, if you just go back to my note for a moment.
Yes.
I have just completed point 17. So I'll just complete the rest of the note and then we'll move on. Point 18. In substance and effect, the DA percentage published by the central government is linked to and determined on the basis of AICPI average as published from time to time. Despite holding that there is no vested right in the state government employees for DA parity with the central government, the tribunal has brought about this parity by insisting that the state government, contrary to its own rules, adopts the methodology of the central government. The device employed by the tribunal is to make an express reference to AICPI and for DA to be revised on the basis of the AICPI number published from time to time, a notion absent in the 2009 rules. In effect, the tribunal has required a departure from the rules, amendment of the rules, by converting a static figure into a dynamic index average for the purpose of arriving at the revised dearness allowance rates. Now, this is, I just wanted to just put it court so that we are trying to respond to the court's query. Now, Manoj, just keep this note with you. And please go back to the ROPA rules, which your lordships will find at page 124, and we were on page 127 of the paper book, first paper book. Now, I want to just make a few comments on the definition of existing emoluments. That's where the notion of DA comes in. So please notice the expression first in Roman 3, dearness allowance appropriate to the basic pay plus dearness pay. Now it uses the words at index average 536. So there is no sliding scale. It fixes it at index average 536. Now the bracketed portion 1982 equals 100 refers to the 1982 series. The 1982 series proceeds on the basis that what was costing 100 rupees in 1982 is to be indexed upwards on an average basis. So the rules are very clear. The rules don't take a sliding scale. Otherwise, it would have said the index average from time to time. Simple under the AI. So you will find there is no reference to the AICPI moving index at all. One. It specifically refers to the number 536. The 536 figure is indicated at with the expression at, so it's a fixed figure, it's a static firm figure, and on the basis of this figure, of course, we keep enhancing the percentage, which we find is required or which is within our capacity, etc. This is the only way, in my respectful submission, this particular rule can be read. It abjures, it stays away from a sliding scale concept, it adopts a static concept, but the static concept is also built in along with the static concept is what your lordship saw the memorandum which was issued and which we referred to at page 162, the 23rd February 2009 memorandum. Paragraph 10. On page 166. Consequent upon the revision of pay of government employees in accordance with the West Bengal service rules, the DNS allowance
Just
to,
one-
yes.
1 minute. Yes.
The
Yes,
Lordship has that DNS allowance.
yes, we are.
These are the modalities. And it says necessary government order in this regard has been issued with the Finance Department memo way back in 2009. And we've set out the 2009 memo at page 168. And the subsequent ones. So for all these years, this is how, this is an understanding. It's a plain language understanding. There is absolutely no question of importing words. Yeah, I can understand somebody saying that, look, this is an arbitrary manner of defining the concept. Then you strike it down. But you can't say there is no right to parity. And then you introduce parity by some fancy footwork by saying that no, please revise, please revisit, keep going back and forth. That I don't believe is a correct concept at all. And so, my lord, your lordship will see in our respectful submission, it does not leave any matter open in terms of a moving index. It fixes it because the composite expression is index average 536. Index average 536. None of the other figures are taken. So this is, my lords, the foundational and the plain language manner of reading it. Now, may I just complete this particular rule because I was just on the rule. There's not very much that I want to indicate. Mr. Subramaniam has also read page 130. Page 130 in the proviso. Here again, the expression is at index average of 536. At index average of 536. It doesn't provide for any dynamic concept over here at all. And then your lordship may just have a look. This is just a point of information. Clause 12 of Rule 12 at page 134.
Areas.
Yeah, but I mean, just a point of information. There's no dispute on this. But notwithstanding anything contained elsewhere in these rules or in any of the rules for the time being enforced, no arrears or pay to which the government employee may be entitled in respect to the period 1st January 2006 to 31st day of March 2008 shall be paid by the to the government employee. And sorry, yeah. So that's where we are. Now, may I? Yeah. Now just go back for a moment to that note and the appendix to the page which we have attached to the note. That's page 3. The lordship should have seen from the 2009 rules that it's benchmarked to 1st January 2006. So that is the rational basis for picking 536. It's specified. Otherwise, the rule might have been challenged by somebody saying, where do you get this figure from, or what's the foundation for DA? So we pegged it to this figure of 536. It eschews and doesn't adopt any of the subsequent figures at all. And therefore, my lords, the rules ought to be given full play. This is our submission. Now, my lords, may I just request you to take up what we handed over in the morning, which was the compilation of judgments.
Yes.
The lordships have that compilation? Yes. So, my lord, may I just first place before you this Jalan Trading Company. We've given the broad heading
Yes.
on the concept of DNS allowance. So, this may be of some assistance. Just please go directly to page 3.
Yes.
So, the judgment, your lordship, begins at page 3. Your lordship has that, Justice Shah's judgment. During the pendency before the industrial court. Your Lordship has that. May I take you over to page 4?
Just one.
Yes, sorry.
Yes.
A synopsis of the development in the industrial law which led to the enactment of the Payment of Bonus Act will facilitate appreciation of the questions argued at the bar. Claims to receive bonus, it appears, were made by industrial employees for the first time in India in the towns of Bombay and Ahmedabad after the commencement of the First World War, when, as a result of inflationary trends, there arose considerable disparity between the living wage and the contractual remuneration earned by workmen in the textile industry. The employers paid to the workmen increase in wages, initially called war bonus and later called special allowance. A committee appointed by the government of Bombay in 1922 to consider inter alia the nature and basis of these bonus payments reported that the workmen had a just claim against the employers to receive bonus, but the claim was not customary, legal, or equitable. During the Second World War, the employers in the textile industry granted cash bonus equivalent to a fraction of the actual wages, not including dearness allowance. But even this was a voluntary payment made with a view to keep labor contented. So this is perhaps a certain background as far as these bonuses and the history of those bonuses are concerned.
Yes.
Now please go to, I would just take your lordships straight away. Where is Union of India? To page. Oh. Yes, sorry. It's page serial number 11, which is 202.
Yes, please.
Your Lordship has that 2007, 7 SCC 472, Union of India versus Arjun Jyoti Kundu.
Yes.
Now here, please go to paragraph 16.
Yes.
We had recently held in K.S. Krishnaswamy, 209.
Yes.
We had recently held in K.S. Krishnaswamy that the recommendations of pay commissions are subject to acceptance or rejection. Speaking for the bench, one of us, Justice Sema, stated, "It is well settled principle of law that recommendation of pay commission are subject to acceptance/rejection with modification of the appropriate government. So unless the government has accepted the recommendation to merge the cadres, the court cannot proceed on the basis of recommendation alone or to direct the government to accept the recommendation. In this context, we have to take note of the decisions of this court in State of West Bengal versus Dev Kumar Mukherjee, that the recommendation on pay scales are not open to judicial review, and the one in State of UP versus Ministerial Karmachari Sangh, to the effect that the evaluation of typists for the purposes of pay scales must be left to the expert body. The role of the pay commission and that of the court has been dealt with in the decision of this court in Saurabh Chowdhury and MP Rural Agricultural Extension Officers Association. In the latter decision, it was held that by this court that pay commissions are constituted for evaluating duties and functions of the employees and the nature thereof vis-a-vis the educational qualifications therefore. Although the pay commission is an expert body, the state in its wisdom and in furtherance of its valid policy may or may not accept its recommendations. So the pay commission recommendations are not binding as far as the state government is concerned. It may accept them, it may in certain situations accept them partially, and then in others reject the app. Now please have a look at four sets of decisions which we want to place with regard to fiscal policy issues. The Lordship goes to the index. Serial numbers 2, 3, 4, and 5.
Yes.
Your Lordships have that. So I'll just place, Manoj, para 21 of Bengal Chemical, page 49. Is where it begins. And if your Lordship is pleased to go to page 56. In Kamani Metals and Alloys versus Workmen, it has been noted that 100% neutralization is not advisable as it will lead to inflation, and therefore DNS allowance is often a little less than 100% neutralization. The following principles broadly emerge from the above decisions. Full neutralization is not normally given except to very lowest class of employees. The purpose of DNS allowance being to neutralize a portion of the increase in the cost of living. It should ordinarily be on a sliding scale and provide for an increase on the rise of cost of living and decrease on a fall in the cost of living. The basis of fixation of wages and DNS allowance is industry cum region. Employees getting the same wages should get the same DNS allowance irrespective of whether they are working as clerks or members of subordinate staff or factory workmen. The additional financial burden, which is a revision of the wage structure or DNS allowance, would impose upon an employer and his ability to bear such burden are very material and relevant factors to be taken into account. Having due regard to the above principles, we are satisfied in the instant case that the tribunal has made substantially a correct approach in considering the claim for revision of DNS allowance. Now, please have a look at the second decision, which is State of Haryana, page 65 at 71.
Yes, please.
The court in the case of Secretary Finance Department versus WB Registration Services Service Association, dealing with the question of equation of posts and equation of salaries of government employees, made the following observation. We do not consider it necessary to traverse the case law on which reliance has been placed by counsel for the appellants, as it is well settled that equation of posts and determination of pay scales is the primary function of the executive and not the judiciary, and therefore ordinarily courts will not enter upon the task of job evaluation, which is generally left to expert bodies like the Pay Commission, etc. But that is not to say that the court has no jurisdiction and the aggrieved employees have no remedy if they are unjustly treated by arbitrary state action or inaction. Courts must, however, realize that job evaluation is both a difficult and time-consuming task, and even expert bodies having the assistance of staff and requisite expertise are found difficult to undertake, sometimes on account of want of relevant data and scales for evaluating performances of different groups of employees. This would call for a constant study of external comparisons and internal relativities on account of changing nature of job requirements. The factors which have to be kept in mind for job evaluation may include the work program, the nature of contribution, the extent of responsibility, the extent of nature of freedoms, the extent of power vested in him, the extent of his dependence on superiors, the need to coordinate with other departments. We have referred to the history of service and the effort of various bodies to reduce the total number of pay scales to a reasonable number. Such reduction is in the number of pay scales has to be achieved by resorting to broad banding of posts by placing different posts having comparable job charts in a common scale. Substantial reduction in the number of pay scales must inevitably lead to clubbing of posts and grades which were earlier different and unequal. While doing so, care must be taken to ensure that such rationalization of pay structures does not throw up anomalies. Ordinarily, a pay structure is evolved keeping in mind several factors: method of recruitment, level at which the recruitment is made, the hierarchy of service, minimum educational, technical qualifications, avenues of promotion, the nature of duties and responsibilities, the horizontal and vertical relativities, public hearings, satisfaction level, employer's capacity to pay. We have referred to these matters in some detail only to emphasize that several factors have to be kept in view while evolving the pay structure in horizontal and vertical relativities have to be carefully balanced, keeping in mind the hierarchical arrangements, avenues of promotion. Such a carefully evolved pay structure ought not to be ordinarily disturbed, as it may upset the balance and cause avoidable ripples in other cadres as well. It is presumably for this reason that the Judicial Secretary, who has strongly recommended substantial hike in the salary of sub-registrars to the Second State Pay Commission, found it difficult to concede the demand made by the Registration Service before him in his capacity as the chairman of the State Pay Commission. There can therefore be no doubt that the equation of posts and equation of salaries is a complex matter which is best left to an expert body, unless there is cogent material on record to come to a firm conclusion that a grave error has crept in and fixing the pay scale for a given post and court's interference is absolutely necessary to undo the injustice. It has to be kept in mind that a claim for equal pay for equal work is not a fundamental right vested in the employee, though it is a constitutional goal to be achieved by the government. Fixation of pay and determination of parity in duties and responsibilities is a complex matter which is for the executive to discharge. While taking a decision in the matter, several relevant factors come, some of which have been noted by this court in decided cases, are to be considered, keeping in view the prevailing financial position and capacity of the state government to bear the additional liability of a revised scale of pay. It's also to be kept in mind that the priority given to different types of posts under the prevailing policies of the state government is also a relevant factor for consideration of the state government. In the context of a complex nature of the issues involved, the far-reaching consequences of the decision in the matter and its impact on the administration of the state government, courts have taken the view that ordinarily courts should not try and delve deep into administrative decisions pertaining to pay fixation and pay parity. This is not to say that the matter is not justiciable or that the courts cannot entertain any proceeding against the administrative decisions taken by government. The court should approach such matters with restraint and interfere only when they are satisfied that the decision of the government is patently irrational, unjust, and prejudicial to a section of employees, and the government, while taking the decision, has ignored factors which are material and relevant for a decision in the matter. Even in a case where the court holds that the orders passed by the government to be unsustainable, then ordinarily a direction should be given to the state government or the authority taking the decision to reconsider the matter and pass a proper order. The court should avoid giving a declaration granting a particular scale of pay and compelling the government to implement the same. As noted earlier, in the present case, the High Court has not even made an attempt to compare the nature and duties and responsibilities of two sections of employees, one in the State Secretariat and the other Central Secretariat. It has also ignored the basic principle that there are certain rules, regulations, and executive instructions issued by the employees which govern the administration of the cadre. Then please, if your lordships are pleased to go to Punjab State Cooperative Milk Producers Federation,
Yes.
which your lordship will find at page 74, at page 97.
Yes.
Go to the page.
Yes.
In KT Veerappa, the court upheld the principle that fixation of pay and parity in duties is the function of the executive, and financial capacity of the government is also a relevant factor to be considered, though on facts, it was held that the employees of the university were entitled to a revision of pay at par with employees of the state. It was held as under. He next contended that the fixation of pay and parity in duties, the function of the executive and financial capacity of the government, and priority given to different types of posts under the prevailing policies of the government are also relevant factors. In support of the contentions, he has placed reliance on so-and-so. However, it is also equally well settled that the court should interfere with administrative decisions pertaining to pay fixation and pay parity when they find such decisions to be unreasonable, unjust, and prejudicial to a section of employees and taken in ignorance of material and relevant factors. In the present case, it is contended that the Federation is a statutory cooperative society. The state government communicated on 1st March 1990 and 9th July 1993 the pay scales as applicable to the Punjab government employees is not to be adopted by the public sector undertakings without taking into consideration the financial health of other statutory bodies and corporations. The Federation has thus taken a conscious and concerted decision to not follow the report of the Anomaly Committee of the state government to grant revised pay scale from 1st January 1986 in view of the precarious financial condition. Moreover, financial assistance had to be availed by the Federation from the state government as well as the National Dairy Development Board. Then please have a look at 10 minutes after that, Tata Cellular, etc.
Yes.
Please go directly. To para 49, which is one of the concerns which we have also taken up. Namely,
One of the Federation was in financial difficulties.
no, not difficulty in the sense it's a question of fiscal outlay for our part. So it has huge ramifications, Manoj. And we have therefore applied our mind and had regard to all these particular factors. So, Manoj, that's one set of decisions. Now, if your Lordship could go to another topic, which I just Mahatma Gandhi mission. Yes. 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 Manoj, please see the decision at serial number 8. Mahatma Gandhi mission versus Bharatiya Kamgar Sena
That is about
begins at page
central
148.
government and state government DA did not be similar.
Yes. At 177, paragraph 62.
Yes.
The fact that the Government of India accepted the recommendations of the 6th Pay Commission, for that matter, any pay commission, does not either oblige the states to follow the pattern of the revised pay structure adopted by the Government of India or create any right in favor of employees of the state or other bodies falling within the legislative authority of the state. The Government of India has no authority either under the Constitution or under any law to compel the states or instrumentalities to adopt the pay structure applicable to employees of the Government of India. I think this is a foundational principle. And in this regard, as Mr. Sibal had indicated,
The moment you bring in Mr. Sibal, we'll ask him to enforce our law.
no, we had actually done some.
Otherwise he is a stock for our
Down to whatever your Lordship.
No, but we had said that we were only expecting that order to be implemented. Partly, of course, that was subject to the outcome of the petition.
There is a,
You may do that, Mr. Sibal. Please ask your client.
there is a constitutional issue here.
No, what we are saying.
So that is also a constitutional issue.
No,
This is
the
our
point
fault.
is,
The
13 states and
implementation of the interim order is a constitutional issue.
25%
of what, Manoj?
of
There is no
area.
calculation.
All.
There is no calculation.
So you have to do the calculation. give
How
it.
can I do it? I have to devise a policy, then I have to devise a framework. That's what
You may fix any amount and give it. You may say this is lump sum amount, but give it.
That means,
Of
that
course,
means.
They subject to the outcome. Of course, see, they are not running away.
No, we are also not running away.
You are, well, they have to be fed.
No, I am not disputing
No,
that. That's not.
See, it's a question of.
I'm not.
So they have
Your
served
Lordship
you.
puts
They are
that
your
to me,
people.
speak.
They have served you. They are
No, I
your people. So give something.
There is no dispute on that.
Please do that. What we are saying. You may give any amount. You may give X amount, but give it. That's what we are saying. Please do that. Please persuade your clients to do that. And this is all subject to the outcome. Yes. Yes, Mr.
So, Manoj, I have also just, if you see my index of authorities,
Yes.
I'm not reading it because it's already quoted portion is read.
Yes.
But you recall that this Kamani Metals and Alloys at
Yes.
serial number 12, AIR 67, Supreme Court 1175. I read that quoted judgment from
Correct.
Bengal.
Correct.
Correct? So, which said that 100% neutralization of inflation may not be advisable in some circumstances. If somebody is doing it, I don't have it. but it's another government.
Yes,
Now, as a point of information, the other judgment which we have placed on the same topic, your Lordship may just know, is Tamil Nadu. Yes, Tamil Nadu Electricity Board, which is at serial number 10.
this is also to the similar effect.
Yes,
Similar effect.
rates may differ. So, would your Lordship, may I just take your Lordships to it? It's at page 189. And you may go directly to page 197.
Yes,
Lordships are para 22.
the main source of finance.
The main source of finance for an electricity board is the state government. The board is run by the state government. Unless the funds are provided by the state government, the electricity board would not have sufficient funds of its own to pay the wages and the revised dearness allowance to its employees. Considering the financial difficulties which the state government was facing, the revision of dearness allowance from the above said rates at the above said rate cannot be said to be arbitrary or without any reason. While considering the grievance of wage structure or dearness allowance, the importance of considering the financial implications while providing benefits to employees has been noted by the Supreme Court in a number of judgments. The Supreme Court in Workman versus Gujarat Electricity Board, while dismissing the appeal preferred by Workman, has confirmed the view that the tribunal which rejected the demand of the employees of the board for dearness allowance, that it should be fixed with the scale prescribed by the Ahmedabad Mill Owners Association, on the ground that the board does not have the capacity to meet the additional expenditure that would have to be incurred if such demands are exceeded. The Supreme Court in Bengal Chemical has laid down that 100%, and Kamani has laid down that 100% neutralization is not advisable, as it will lead to inflation, and therefore dearness allowance is often a little less than 100% neutralization. Explaining the purpose of the dearness allowance, and that should depend upon the ability of the employer to bear such burden. The Supreme Court held in Bengal Chemicals, full neutralization is not normally given except to the very lowest scale. The purpose of dearness allowance being to neutralize a portion of the increase. This is Manoj, which I had quoted and read.
Yes, correct.
And that additional financial burden also. So Manoj, this is a consistent principle which is to be followed. Now, the only point which I wanted to make was that as far as we have been able to ascertain, apart from West Bengal, the states of Kerala, Chhattisgarh, Himachal Pradesh, Karnataka, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Telangana, and Tripura, which is a total of 13 out of the 27 states as well we have been able to ascertain, do not follow the rates of DA declared by the central government. So they have their own, we all have our, yeah. So it's a distinct scheme depending on our facts and circumstances. But I'm very grateful, but may I just commit, we sort of divided our...
Certainly.
So if we could just have some supplementary...
7 minutes, not much.
Yes. In fact, Mr. Divana actually covered everything.
That's right. I'm not going to touch on any of the things that he has said.
Please.
I'm just apropos what fell from your lordship. Now, if you look at, as I was indicated earlier, you look at the 7th schedule, there are 2 entries which are very important.
Yes.
One is for this entry 41, state public services. So, when a finance bill is presented in the legislature, and
Yes.
appropriation is done with respect to the expenditure, with respect to salaries and all components of salary. Right? Without that, no payment can be made.
Yes.
So whether it is dearness allowance along with salary, that has to be part of the appropriation bill. Outside of that, no payment can be made.
Correct.
Then if you look at entry 43, is public debt.
Yes.
Public debt of the state, mothers, is an important factor in deciding how much money is to be disbursed.
Please.
And we have the FRBM, the Fiscal Responsibility Act, in terms of which my deficit is fixed. If I go beyond that, then consequences follow. Right? Now, public debt is exclusively in the domain of the state.
Yes.
And state public services, including all salaries, dearness allowance, all aspects, exclusively in the domain of the state.
Yes.
So the problem that arises is when the consumer price index is foisted onto the state models. If supposing there was an act, well, let's forget this, All India Consumer Price Index. Supposing there was an act of parliament, it would not pass muster saying you give this dearness allowance. It would not pass muster. So no tribunal, no authority can give a direction in law saying you to follow the All India Consumer Price Index.
Yes.
Because it's outside the jurisdiction of the tribunal, outside the jurisdiction of the Union of India. That is why it's
Even this court.
no. This court is Mother Article 142.
No, even this court.
So, Mother, the point, your Lordship asked me a very important question. Why can't you give it, Mother? Now, how will I give it? I'll have to borrow money. For borrowing money, I'll have to go to the Reserve Bank of India. The Reserve Bank of India will have to allow me, depending on my public debt. Then I'll have to go to the state legislature, pass an appropriation bill. Then the money can be disbursed. That's the procedure, Mother. I can't give it just like that. So, Mother, there are several aspects. And Mother, this has happened in the past. During the COVID period, no dearness allowance was paid. In Bihar, Mother, floods take place, enormous expenditure takes place. How can the state legislature even afford to pay sometimes? This happens also in Himachal Pradesh. This happens in Uttarakhand, right? A tsunami may happen, whether in the coastal areas. Our Manrega salaries are not paid. I have to pay them from my own pocket. There are so many issues that arise, Mother. So we have to have the fiscal space to pay this, right? Now, Mother, how can that be done by a direction of this nature? It's not possible. So when your Lordships put it to me, Mother, there is a whole process that has to be followed. I can't just do it like that. Now, in the absence of that process, there can't be a direction. And actually, the whole judgment suffers from that basic error that an All India Consumer Price Index can be foisted on the state government to add it to the salary, indexed it in the way that they want.
Yeah.
Because as a constitutional issue, it's not possible to do that.
Very well. Thank you. Anyone say anything?
There's a short list of dates that I had prepared, and there's a short note of submissions.
Yes, Mr.
Now, the first entry, your Lordship say only, you had the 5th Pay Commission recommendations on 12/2/2009.
Correct.
And my lords, they recommended sanctioning 2 installments of DA. Your Lordship will get that from page 97 to 99.
Yes.
Now, this recommendation was not implemented by us. We did not accept this recommendation. So, while framing ROPA, we didn't say that give DA twice a year, nor did we say that you adopt central government things. So, that's very clear. Your Lordship gets that in the second entry.
Yes.
And your Lordship will get that at the pages that I have mentioned.
Okay.
That ROPA did not really pick up this particular aspect.
Yes.
Now, at the first instance, my lords, when the OA was filed, it was filed, my lords, for implementing the recommendations of the Pay Commission. The OA was refused. And the OA was dismissed. Your Lordship will get that judgment at page 197 to page 230 of the special legal.
Yes.
Then the matter, my lords, went back to the tribunal on a remand.
Yes.
And it is on the remand that the impugned judgment was passed on 26/7/2019.
Yes,
So I'm just handing over these dates, just for the sake of clarity.
please.
Then, your Lordship will just come to how the High Court dealt with this particular aspect. And the High Court proceeded on the basis that we had accepted the recommendation of the Pay Commission, which is a fundamental fallacy in the judgment of the High Court. If your Lordship sees the reasoning from page 18.
You want us to read the High Court judgment?
Yes, volume 1.
Yes.
I'm only trying to point out that perhaps with the greatest respect, the High Court actually missed the point. Just see from page 19 onwards, paragraph 18.
Paragraph?
Paragraph 18, page 19.
Okay.
The aforesaid recommendation.
Just one.
Yes.
Yes.
In fact, if your Lordship reads from page 17,
You want us to come to page 7?
page 17, first paragraph 17.
Yes.
The Fifth Pay Commission under Chapter 10, relating to allowances amongst others, reported and recommended as under.
Yes.
And then your Lordship comes to 10.6 at page 18. It is evident from the above that the state government sanction of installment does not follow any definite pattern. It is also clear that there are delays in payments of various installments of DA. There cannot be any differences of opinion regarding the need to avoid the delays. We are of the opinion that some extra effort, the state government should be in a position to clear the backlog of loan installment, which was sanctioned by the Government of India with effect from 1st July 2008, and then fall in line with the central government pattern of sanctioning 2 installments of DA each year. We recommend this course of action. If it is done, it will mitigate a long-standing grievance of almost all the employees within our terms. The aforesaid recommendation of the Fifth Pay Commission has been accepted by the government by promulgating ROPA Rules 2009. This is factually incorrect. Because A, the ROPA rules don't speak about adopting this particular basis. Secondly, there is nothing in the ROPA rules with regard to revision twice a year. As per Rule 3C, existing emoluments mean aggregate of one existing basic pay, DNS pay appropriate to the basic pay, and DNS allowance appropriate to the basic pay at index average 536, 182 is equal to 100. As quoted above, the coordinate division bench in the judgment has held that the claim of the employee serving under the Government of West Bengal for DNS allowance is based on a legally enforceable right of all the employees serving under the Government of West Bengal up to such extent of the recommendations of the Pay Commission, which has been accepted by the Government of West Bengal by virtue of the provisions of Sub-Rule 1 of Rule 12 of ROPA rules, read with paragraph 10 of the clarificatory memorandum, being number such and such, dated 23rd February 2009, on the ROPA rules by the Government of West Bengal Finance Department. Audit grant in paragraph 3 of the memorandum, bearing number 1692, dated February 23, 2009, in the matter of withdrawal of DNS allowance in revised pay structure under the ROPA Rules 2009, issued by the Government of West Bengal. This observation, as stated above, has attained finality. Therefore, we have no hesitation in our mind to hold that state government employees under the ROPA rules has acquired a legally enforceable right to get DNS allowance at the rate to be fixed on the basis of All India Consumer Price Index as embedded in Rule 3C of the ROPA Rules 2009. Now, there is nothing, my lords, in the ROPA Rules of 2009, as was pointed out by my learned friend Mr. Revan, that this dynamic price index is adopted by the state under the ROPA Rules. So, this is, my lords, an error on the face of the record. The High Court proceeds on a basis which is factually incorrect. And then, my lords, your lordship sees further, in view of the decision in the coordinate bench, the employees under the West Bengal State Electricity Transmission Company are entitled to DNS allowances at the rate of the central government. The learned tribunal in the impugned judgment has struck down the relevant office orders and memorandums under which DA was paid to state government employees working in Banga Bhavan in New Delhi and youth hostel at Chennai at the rate payable to the employees of the central government holding that the orders or memorandum discriminate, offending the doctrine of equality under Article 14 of the Constitution, bearing in mind the principles enunciated by the Honorable Apex Court in its decision in the case of Nakara, reported in such and such. We hold that the classification of the state government employees working as West Bengal and the state government employees working at Delhi and Chennai, governed by the same statutory rules, is discriminatory, sounds intelligible differences, and offends the golden doctrine of equality under Article 14 of the Constitution. Since the claim of the state government employees of DNS allowance at the rate to be calculated on the basis of All India Consumer Price Index has fructified into a legally enforceable statutory right, cite AIR 1961-86, cited by the learned Advocate General, pertaining to payment of DNS allowance to workmen, whose conditions and services are contractual in nature under private individuals or organizations, are not applicable to the facts of the case on hand. Similarly, in view of the factual and legal scenario, the above decisions in the state of Tamil Nadu are not applicable. And then in paragraph 23 and 24, which was placed by my learned friend Mr. Diwan, which I don't need to read, Malod, it is held, their lordships have come to the conclusion that grant of DA on the basis of this particular rate would be a fundamental right, with which, Malod, even the other side has said that it does not really press the point, so I don't need to read. The fundamental fallacy in the judgment of the High Court is that it assumes that the ROPA rules actually incorporate a dynamic consumer price index, which is totally wrong. In fact, Manoj, that is apparent from the definition of the word existing emolument, which freezes for a particular base at the year 2006, which is then adopted and used as a base. It doesn't say that the price index will be the same. I asked myself another question, and I'll just read two passages from the tribunals. The tribunal, on the one hand, comes to an express conclusion that you can't import central government rates to the state government for the purposes of DNS. And it says that there is no right in this regard to do that. Now I ask myself this question, that if this is not static and if it is dynamic, what would be the ultimate end result? The ultimate end result is the same. Because if you adopt that particular rate, that is the rate which the central government adopts, and that will be the end result. So there are, Manoj, two points of contentious aspects in the order of the tribunal, which I want to point out. If, Manoj, we were told that you fix the norms, etc. The norms, etc. have already been fixed by us by virtue of notification. But it doesn't stop there. It says it uses the expression time to time, and it says twice a year, which are both, Manoj, practices followed by the central government. And that is, Manoj, where the error has crept in the judgment of the tribe.
How has the second judge dealt with second judge?
It's similar.
Similar.
Yeah.
Has he given any other reasoning?
No.
No other reasoning is given?
I can place the findings.
No, we only. Is there any reasoning has been
on this aspect? There is no reason.
So there is no reason. Okay.
In fact, Manoj, if your lordship sees,
no, we have understood your point.
At page 39 and 40 is, Manoj, the finding
according to you
of the
lordship, in view of what Mr. Diwan has argued, Mr. Simple has argued, according to you, in view of 3C Roman 3, which is static in nature, there is error in the finding that para 33 of the tribunal as also the High Court.
Lordship.
So therefore, there no mandamus could have been issued, more so by the tribunal.
Lordship. And your lordship will just see, Manoj, those two particular findings of the tribunal, the use of the expression time to time, from time to time, which your lordship will get at page.
Yes.
Page 484, paragraph 33.
Page
484, paragraph 33. This is where the rub comes.
484.
Page 484, that's in volume 2.
Yes. Para 33.
Para 33. We have already observed.
Just
Yes.
We have already observed that there is no mandate under the statutory rules, viz. ROPA Rules 2009, or in the administrative directions issued by the central government in the form of memorandum number 1691-F dated 23rd February 2009 and memorandum number 1692-F dated February 23, 2009 that DA will be paid to the employees by the state government at a rate from the date as paid by the central government to its employees. In the absence of any mandate under the statutory rules or the administrative direction, we are unable to hold that the state government employees are entitled to get DA at a rate payable to its employees by the central government. However, from the discussion made by us here and above, we can hold without hesitation that state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time. By taking the base year 1982, that is 1982 is equal to 100. Now, this is one of the first difficulty. How do you incorporate from time to time, which means Malod's a dynamic index, which is not part of the ROPA rules at all. And further, it is a bounden duty of the state government to evolve norms, principles for payment of DA to its employees by calculating.
Anyone else this
Yeah.
time?
Then, Malod, my written note,
You can keep it.
I've just yes. It just encapsulates all the points.
No problem. We'll go through. Is there, Mr. Diwan is not there, Mr. MD is there. Mr. Gopal Subramanian, we'll tell you. We don't shy away from saying so we want to help. You are government employees, you serve the government, you will have to tell us how can we help. We'll continue there.
And what we have understood is that having held that court cannot issue a mandamus for grant of central DA. Now the court has granted it, according to them, court has granted the same by applying ACPI. That is the crux. That is what their submission is.
Correct.
Having said that, it can't do, they have done it, the High Court and the tribunal, by applying ACPI,
That's the point.
According to us, what the High Court and the Tribunal.
and according to you and the High Court, ACPI, the application of this, what is this, ACPI,
Yes.
AICP, is inbuilt in 3C.
Built the rule.
Inbuilt in 3, that is your case.
Yes, and it is from time.
Court has not applied any alien formula, it is inbuilt in 3C3, that is what your case.
Yes.
Their case is, the rule makes it static. We say,
We can't be more clearer than this.
correct.
As of now, the task is not as simple.
We are testing us whether we have understood.
These are very fair questions to be answered.
Well, there's only one aspect I want to say. Any order of your lordships in this context is going to impact all states in India.
All
But
states
kindly have.
who have not chosen central DA.
I'm sorry?
All states who have not chosen central DA.
And therefore,
Not all.
when they have modifications, they will be deeply interested in this issue. That's what I'm saying. Maybe your lordships might think in terms of actually hearing them, because this impacts them directly.
We'll certainly consider.
It's something very important.
We'll certainly consider.
Yes, sir.
It's a very valuable
That's
suggestion.
right.
We'll consider.
Please do.
We'll ponder over it.
Yes, sir.
Definitely tomorrow
Because
we are.
the federal structure is at stake.
In fact, no, in the morning only we said, yesterday we said, we're going to have all India panel.
Exactly. It's not just a West Bengal matter.
Correct.
Your every case is pan India, Mr. Sibal.
We are confined to our own state rules anyway.
Just
Except that I don't have any impact pan India.
No, can't say that.
I wish I had.
Yes, one more aspect, because if I may just point out,
Confined to the
In a-
state rules.
in our application, which we had made, we have given certain figures because the fiscal aspect is something which your lordships have stressed. As to the extent of burden, which will-
36,000 crore.
yes, and the extent of burden that will fall on us. But your lordship may just bear in mind page 5 onwards of that application, because we've given figures.
Mr. Singhvi, in
Well,
fact,
many
has been
ancillary
saying
questions
this,
would come if there is this.
1 minute, sir, please, we have not finished. We have not called upon you, sir.
Oh, that's
But nonetheless, we have told you the difficulty which is there. If you read the code by now. So therefore, we can't be more candid in this.
that's
We want to help you. Tell us how best we can help you.
that's true. They also try to put that assist your lordship at that exchange.
Obliged.
Page 4 onwards of my application, I gave all those figures.
Tomorrow.
Huh?
It's no problem.
मैक्सिमा के तहत इसको डिस्पोज नहीं करेंगे, देन अगर इसको आप डिस्पोज नहीं करेंगे, देन क्या प्रॉब्लम होगी कॉन्स्टिट्यूशनल आप जानते हैं। इट्स आवर ऑब्लिगेशन। जब से सत्र चल रहा है हमने एक बिल छोड़कर कोई काम नहीं किया है। प्लीज इसके महत्व को समझे। माननीय जयराम रमेश जी आप लंबे समय तक सत्ता में रहे हैं, आप समझते, आप लंबे समय तक सत्ता में रहे हैं, आप इसके महत्व को अच्छी तरह जानते हैं। प्लीज नो, आई विल मूव Shri Nityanand Rai to move the following resolution. Please, we are now going to take up the statutory resolution with regard to extension of the proclamation issued by the Honorable President in respect of the state of Manipur. I sincerely hope that members will rise to the occasion, use the floor meaningfully and utilize the time at their disposal in manner befitting the gravity of the matter and fulfill the constitutional obligation. ये constitutional obligation है. Please go back to your seats. Please go back to your seats. Shri Nityanand Rai to move the following resolution.
महोदय, मैं संकल्प प्रस्तुत करता हूं कि यह सभा संविधान के अनुच्छेद 356 के अधीन मणिपुर के संबंध में राष्ट्रपति द्वारा 13 फरवरी 2025 को जारी की गई उद्घोषणा के 13 अगस्त 2025 से और 6 महीने की अवधि के लिए प्रवृत्त बने रहने का अनुमोदन करती है।
Please, I shall now call upon the members whose names have been received for the participation in the discussion. Please, श्री इमरान प्रताप गढ़ी, माननीय श्री इमरान प्रताप गढ़ी, आप अपनी सीट पर नहीं, आप वहां जाएं और बोलें। आप इस महत्वपूर्ण विषय पर जाकर बोलें। आप अपनी सीट पर नहीं है तो आपकी कोई बात रिकॉर्ड नहीं। प्लीज गो बैक टू योर सीट। आप बोलने में रुचि नहीं रखते। सुश्री सुष्मिता देव जी, प्लीज। सुष्मिता जी, आपकी बात रिकॉर्ड पे जाएगी। प्लीज स्पीक।
सर, SIR पे चर्चा कराइए।
इट्स नॉट गोइंग।
मणिपुर में हम
आप नियम जानती हैं सुष्मिता जी, बड़ी बहुत अनुभवी हैं आप।
एक मिनट सर,
आप लोकसभा राज्यसभा
सब पॉइंट ऑफ ऑर्डर।
यस,
रूल नंबर 259 The chairman shall preserve order and shall have all power necessary. Please tell the treasury benches to allow us to debate SIR.
You all are creating disorder. आप इंटरेस्टेड नहीं सब्जेक्ट पर बोलने के लिए, इट विल नॉट गो ऑन द रिकॉर्ड। श्री तिरुचि शिवा जी, ऑनरेबल तिरुचि शिवा, प्लीज स्पीक। योर नेम इज हियर।
गिरिराजन।
Although your name is mentioned, I will call Girirajan. I will call like you say, sir. I will call.
So we shall discuss about SIR, sir.
Sir, no, not going on record.
The House is
not going on record. You are a very seasoned, senior person. You know the rules. जिस विषय जो विषय यहाँ लिस्टेड है उसी पर बात हो सकती है। नो, श्री सुभाष चंद्र बोस पिल्ली, प्लीज स्पीक। आपकी बात ही रिकॉर्ड पे जाएगी और कोई माननीय सदस्य प्लीज उन्हें बोलने दे, डिस्टर्ब न करे, ये उनका लोकतांत्रिक अधिकार है। सुष्मिता जी गो बैक टू योर सीट। सुष्मिता जी गो बैक टू योर सीट। आपकी बात रिकॉर्ड पे जाएगी। यू स्पीक। केस देख रहा है कि किसी को बोलने के लिए स्टैच्यूट पर कैसे आप लोकतांत्रिक काम कर रहे हैं। अपनी सीट पर वापस जाइए।
decision that has not been taken by in the region. Manipur, a land of Christian culture, diversity, has unfortunately been gripped by prolonged communal and religious clashes, lawlessness, and total breakdown of administrative machinery. Over the past year, we have witnessed the incidents of violence, destruction of homes, displacement of thousands,
वोट की चोरी बंद करो।
such circumstances, continuing
SIR पे चर्चा
not a choice, but constitutional compulsion. The safety of citizens must always come before political calculations. Despite of several attempts, reconciliation and peace building, the social fabric remains fragile. The local administration has struggled to restore normalcy, and the areas remain as it is. The Constitution of Indian government as empowers to authorize legal precepts to impose a presidential rule when there is future of constitutional machinery, and in the case of Manipur, it is evident that the local administration has not been able to discharge its duties in accordance with the Constitution. Under President's rule, the Union government, with the governor and central forces, has been able to initiate impulsive and focused efforts to secure the region, rebuild institutions, and pave the way long-term reconciliation. However, this process requires more time restoring last pieces not in and especially when years and mistrust social and political security. Therefore, I submit that the action of President Nehru is in best interest of Manipur and the people, not just restore law and order, but to enable durable framework for peace and justice and inclusive development. Sir, one important issue, sir. The situation in AP is also similar. I therefore request the central government to consider imposing presidential rule in Andhra Pradesh to bring order in the state. Thank you, sir.
थैंक यू माननीय श्री मुजीबुल्लाह खान, माननीय मुजीबुल्लाह खान।
सर, जब मणिपुर का हालत खराब हुआ, मणिपुर का लॉ एंड ऑर्डर सिचुएशन खराब हुआ, तो वहां 356 लगाया गया। ठीक है, राष्ट्रपति जी लगाए 6 महीना बढ़ाने के लिए बोल दिया, अच्छी बात है। लेकिन आज उड़ीसा का जो हालात है, महिला लोग जो सुरक्षित है,
आप इसी विषय पर बोलेंगे वही रिकॉर्ड पे जाएगा। आप नियम जानते हैं मुजीबुल्लाह जी। आप अगर मणिपुर पर बोलेंगे वो रिकॉर्ड में जाएगा, कोई और बात बोलेंगे नियमता वो रिकॉर्ड पे नहीं जाएगा। बोलिए मणिपुर।
ठीक है सर, मैं इतना ही कहना चाहता हूं कि आज के जो हालत है, मणिपुर में भी वो डबल इंजन सरकार था और फेलुअर हो गया। उसके बाद सब राष्ट्रपति शासन लगाया गया है। अब इतना दिन राष्ट्रपति शासन के बाद अभी क्या सिचुएशन है, उसका हालत सुधरा है कि नहीं सुधरा है, उसके बारे में माननीय मंत्री जी हमको जानकारी दे। कौन से पोजीशन में भी है, आगे चल के जो होगा, जो हालत होगा, उसके लिए केंद्र सरकार भी जिम्मेदारी ले और ऐसा बार बार राष्ट्रपति शासन लागू करना, एक निर्वाचित सरकार को हटाना भी उचित नहीं है। धन्यवाद।
डॉक्टर वी शिवादासन नॉट प्रेजेंट। श्रीमती जेबी माथेर हिसम, go back to your seat and speak, please. So you are not interested in speaking. Sri R. Girirajan, I am calling Sri R. Girirajan, go back to your seat and speak. And speak on the subject as per rules. Girirajan ji, you speak on the subject as per rules.
Chairman sir, first we have a discussion on it.
Not going on record. Speak on Manipur.
Only SIR.
Manne Sri Haris Biran, not there. Sri PP Suneer, not there. Sri Ramji, not there. Mani Sanjay Kumar Jhaji, not there. Sri Javed Ali Khan, नहीं है। Honorable members, don't come in the bill. Sushmita ji, I'm warning you. Don't come in the bill. Please go back to your seat. No. As I've already indicated, this motion is a constitutional obligation. I once again request honorable members to maintain order and participate meaningfully in the discussion, kindly allow the proceedings to be held smoothly and allow those members to speak who wish to participate in the debate. Please, जो लोग वेल में है, please go back to your seats. श्री नित्यानंद राय to reply.
महोदय, सबसे पहले तो मैं यह बताना चाहूंगा कि एक हाई कोर्ट के फैसले के कारण मणिपुर में 2 समुदायों के बीच आरक्षण संबंधी विवाद के कारण जातीय हिंसा भड़क उठी है। और जो लोग कहते हैं वह धार्मिक हिंसा है, वह बिल्कुल ही गलत बोल रहे हैं। और एक राष्ट्रपति शासन के बाद की स्थिति क्या है, मैं उनको बताना चाहूंगा कि राष्ट्रपति शासन लागू हुए 8 महीने हुए हैं। 8 महीने में सिर्फ 1 हत्या हुई है। महोदय, राष्ट्रपति शासन लागू हुए 8 महीने हुए हैं। 8 महीने में हिंसा में इधर के 4 महीनों में एक भी मौत नहीं हुई है। जब मणिपुर में हिंसा भड़की थी, उसके बाद माननीय गृह मंत्री जी ने मणिपुर राज्य के हिंसा प्रभावित क्षेत्रों का दौरा हुआ। दौरा के दौरान उन्होंने उच्च अधिकारी, सुरक्षा बलों और सामाजिक संगठनों के साथ 100 से अधिक सदस्यों के साथ उन्होंने मीटिंग की। आज वहां शांति व्यवस्था है। वहां माननीय महोदय प्रधानमंत्री जी के विकास दृष्टिकोण के कारण वहां नॉर्थ ईस्ट में इतना विकास हुआ है। महोदय, मैं अनुरोध करता हूं कि मणिपुर राज्य के संबंध में संविधान के अनुच्छेद 356 के तहत राष्ट्रपति द्वारा दिनांक 13 फरवरी 2025 को जारी की गई घोषणा को इस सदन द्वारा अनुमोदित करने की कृपा करें। मैं अनुरोध कर रहा हूं, संविधान के तहत निर्धारित घोषणा के प्रत्येक परिणामी आदेश के साथ सदन के पटल पर रख दी गई है।
The question is put. Those in favor will please say aye. Those against will please say no. You have to go back to your seats. Then you can say only no. मैं आपको पुनः मौका देता हूं कि आप अपनी सीट पर जाइए। नो कहने का आपको अधिकार है, डिस्पोज करने का अधिकार है, वेल से नहीं है। I'll read. प्लीज गो बैक टू योर सीट्स। वेल से आप किसी तरह के अधिकार की मांग नहीं कर सकते। प्लीज गो बैक टू योर सीट्स। Those in favor will please say aye. Those against will please say no. I think the ayes have it. The statutory resolution is adopted. The House stands adjourned to meet at 11 a.m. on Wednesday, the 6th August 2025.
Thank you, Speaker Sir, for letting me speak on a very important, painful subject. I start with the attack in Pahalgam. a brutal attack, heartless attack, organized and orchestrated clearly by the Pakistani state. Merciless, young people, old people murdered in cold blood, mercilessly. And we have together, every single person in this house condemned Pakistan. The moment Operation Sindoor began, in fact, even before it began, the opposition committed itself, all the parties, that we will stand like a rock with the forces and with the government of India, with the elected government of India. We heard the odd jibe, the sarcastic remarks from some of their leaders, but we said absolutely nothing. And this was something that was agreed among all the senior leadership of the India Alliance. And we are very proud that as an opposition, we stood united as we should have. Speaker sir, पहलगाम के बाद मैं करनाल में नारवाल जी के घर गया। उनके बेटे नेवी में थे, वो सीआरपीएफ में थे। मुझे ऐसा लगा कि मैं अपने परिवार के साथ बैठा हूं। 2 घंटे में बैठा। उन्होंने अपने बेटे के फोटोग्राफिक एल्बम दिखाया मुझे, जब वो छोटा सा बच्चा था। उसके बारे में बताया, मजाक करता था, जोक्स करता था, और एक प्रकार से परिवार के बारे में मुझे बताया। 2 घंटे बात हुई। बहन ने कहा कि मैं दरवाजे की ओर देखती हूं, मेरा भाई नहीं आता है, कभी आता ही नहीं है और कभी नहीं आएगा। उसके बाद यूपी में दूसरे परिवार से मिला। पति को बीबी के सामने, वो काउंटर पे कुछ खरीद रहा था, बीबी के सामने गोली मारी। दर्द होता है, हर हिंदुस्तानी को दुख होता है, दर्द होता है। जो हुआ गलत हुआ, सबने कंडेम किया। स्पीकर सर, राजनीतिक काम करते हुए हम पूरे देश में जाते हैं, घूमते हैं, लोगों से मिलते हैं, दुख में, सुख में। जब भी मैं फोर्सेस के किसी भी व्यक्ति से मिलता हूं, जैसे ही मैं हाथ मिलाता हूं, और ये आपको भी फील हुआ होगा, जैसे ही मैं हाथ मिलाता हूं, मुझे पता लग जाता है कि ये हिंदुस्तान की फोर्सेस सेना का आदमी है। हाथ जैसे मिलाता है, मुझे पता लग जाता है कि ये टाइगर है। इसको हिलाया नहीं जा सकता, ये देश के लिए मर जाएगा, सीधा खड़ा रहता है। इसको कहीं भी भेज दो, ये देश के लिए लड़ने के लिए, मरने के लिए तैयार रहता है। सर, टाइगर को पूरी फ्रीडम देनी पड़ती है। टाइगर को आप बांध नहीं सकते हो। अगर आपने टाइगर से सच्चा काम लेना है, पूरा काम लेना है, तो आपको टाइगर को पूरी छूट देनी पड़ेगी। सर, दो शब्द हैं, एक पॉलिटिकल विल और दूसरा फ्रीडम ऑफ ऑपरेशन। मतलब अगर आप हिंदुस्तान की सेना, एयरफोर्स, नेवी का प्रयोग करना चाहते हो, आपके पास सबसे पहले 100% पॉलिटिकल विल होनी चाहिए, और दूसरा, अगर आप सेना का प्रयोग करना चाहते हो तो आपको फुल फ्रीडम ऑफ ऑपरेशन देना पड़ेगा। राजनाथ सिंह जी ने अपने भाषण में कल 1971 और सिंदूर का कंपैरिजन किया, और मैं उनको याद दिलाना चाहता हूं, 1971 में पॉलिटिकल विल थी। इंडियन ओशन में 7th फ्लीट आ रही थी, हिंदुस्तान की ओर आ रही थी, और उस समय के प्रधानमंत्री ने कहा, हमें जो बांग्लादेश में करना है हम करेंगे, आप आ जाओ, जितना आना है आ जाओ, हम करेंगे। पॉलिटिकल विल, विदाउट एनी कंफ्यूजन। सुपर पावर ऑफ द वर्ल्ड इज कमिंग with its aircraft carriers, hundreds of aircraft, political will. The Prime Minister of India says, we don't care. Come. But हमारा जो काम है हम उसे पूरा करेंगे। जनरल मानेकशॉ ने इंदिरा गांधी जी से कहा कि मैं ऑपरेशन गर्मी में नहीं कर सकता हूं, नहीं करूंगा, मुझे 6 महीने चाहिए। इंदिरा गांधी जी ने उन्हें कहा, आपको 6 महीने चाहिए, 1 साल चाहिए, जितना भी आपको समय चाहिए आप लीजिए, क्योंकि आपको फ्रीडम होनी चाहिए, फ्रीडम ऑफ एक्शन आपको होना चाहिए, फ्रीडम ऑफ मैनूवर आपका होना चाहिए। 1 लाख पाकिस्तानी सोल्जर सरेंडर किए, एक नया देश बना। सर, लेट अस नाउ मूव टू ऑपरेशन सिंदूर। Yesterday I watched राजनाथ सिंह जी का भाषण में सुन रहा था, and I listened quite carefully when people speak. And Rajnath Singh ji said that Operation Sindoor began at 1:05 in the morning. और उसके बाद उन्होंने कहा, he said, Operation Sindoor lasted 22 minutes. And then he said the most shocking thing. He said at 1:35, we called Pakistan. We called Pakistan at 1:35 and we told them that we have hit non-military targets and we do not want escalation. These are the words of the Defense Minister of India. Now, maybe he does not understand what he revealed. The DGMO of India was told by the government of India to ask for a ceasefire at 1:35 at night itself, on the night of Operation Sindoor. You told the Pakistanis exactly what you would do. You told them that we will not hit military targets. You told them we do not want escalation. Speaker sir, you imagine, दो लोगों के बीच में लड़ाई हो रही है, दो लोगों के बीच में लड़ाई हो रही है, एक आदमी जाके दूसरे को घूसा मारता है और फिर कहता है देखिए मैंने घूसा मार दिया, अब एस्केलेशन नहीं कीजिए। मतलब आपने पाकिस्तान को डायरेक्टली अपनी पॉलिटिकल विल बता दी कि आपके पास लड़ने की पॉलिटिकल विल है ही नहीं, कि आप लड़ना ही नहीं चाहते हो। और ये डिफेंस मिनिस्टर ने कहा है कि हमने, डिफेंस मिनिस्टर यहां हाउस में कहने कि हमने पाकिस्तान से जाके कहा कि हमने आपको एक झापड़ मारा है, मगर हम आपको और झापड़ नहीं मारेंगे। हम एस्केलेशन नहीं चाहते हैं, आप रिस्पॉन्ड नहीं कीजिए और हम मिलिट्री टारगेट नहीं मारेंगे। मीनिंग द गवर्नमेंट ऑफ इंडिया informed the government of Pakistan that we have no political will, we don't want to fight, we have done this, we have just done this action. Surrender, immediate surrender in 30 minutes. Now there is a second very important thing that Rajnath Singh ji said. Maybe he didn't mean to say this. He also said that he told the Pakistanis that we are not going to hit any of your military infrastructure. Now this is a very interesting fact, because, and I want you to listen carefully to this, I said freedom of maneuver, meaning freedom to the Air Force. Now listen to this quote very carefully. Captain Shiv Kumar, Defense Attaché, Indonesia, he says, I may not agree with him that India lost so many aircraft, but I do agree that we did lose some aircraft. And that happened only because, of the constraint given by the political leadership to not attack the military establishment and their air defense. Meaning you went into Pakistan, you attacked Pakistan, and you told our pilots, do not attack their air defense system. Meaning you told our pilots, go and attack and face the air defense system of Pakistan. Meaning you tied their hands behind their back. Right? And the defense minister has said this in Parliament House itself, that we told the Pakistanis that we are not going to attack their infrastructure. इन्होंने बोला publicly house में कि भैया हम आपके जो मिलिट्री इंफ्रास्ट्रक्चर है, आपके एयर डिफेंस सिस्टम को हम नहीं अटैक करेंगे, और दूसरे साइड से आप हमारे पायलट भेज रहे हो, क्या होगा? हवाई जहाज गिरेंगे, right? So the point is, aircraft were lost, as this gentleman Shiv Kumar says, they were lost because of the constraint given by the political leadership to not attack the military and air defense infrastructure of the Pakistan. मतलब आपने शुरू किया और शुरुआत में आपने उनको कह दिया कि भैया हमारे पास ना पॉलिटिकल विल है और ना हम आपके मिलिट्री इंफ्रास्ट्रक्चर पर अटैक करेंगे, और फिर आपने हमारे पायलट से कहा जाके लड़ाई करिए, और नतीजा सारों को मालूम है। आप जवाब नहीं देना चाहते हो, मगर नतीजा सारों को मालूम है। अनिल चौहान जी कहते हैं, what was important was not the jet being down, but why they were being down. मतलब वो कह रहे हैं कि जरूरी सवाल ये है कि जेट गिरे क्यों। वो कह रहे गिरे तो ठीक है, मगर जरूरी सवाल है गिरे क्यों। और फिर उसके बाद कहते हैं what mistakes were made. The good part is we were able to understand the tactical mistake which we made, remedy, rectify, and implement after 2 days. And we flew all our jets again, targeting at long range. I want to tell CDS Anil Chauhanji that you made no tactical mistake. The Indian Air Force made no mistake.
Yes.
The mistake was made by the political leadership that said you cannot attack the military infrastructure. And Anil Chauhanji must have the guts to say this. That my hands were tied behind my back and I was sent into a war and my enemy was told by my own government that we will not attack your air defense system. So the Air Force is not to blame at all. In the 21st century, you send aircraft into a zone protected by air defense, they will come down. Now why? Why was the Pakistani government told at 1:35 that हम ना आपके इंफ्रास्ट्रक्चर को अटैक करेंगे, ना आपके एयर डिफेंस को अटैक करेंगे, और हम एस्केलेशन नहीं चाहते? मतलब हमने आपको थप्पड़ मारा है मगर दूसरा थप्पड़ नहीं मारेंगे. That is what it means. When we say we don't want escalation, it means मैंने एक थप्पड़ मारा, दूसरा नहीं मारूंगा, तीसरा नहीं मारूंगा, चौथा नहीं मारूंगा. Why? Because the goal of this exercise was to protect the Prime Minister's image. Yes. The goal of the exercise, because he has the blood of the people of Pahalgam on his hands, the goal of the exercise was to make sure that he used the Air Force to protect his image. Yes. Yes. After that, Donald Trump has said 29 times. 29 times he said, 29 बार उन्होंने बोला कि भैया मैंने सीज फायर करवाया. अच्छा, अगर वो झूठ बोल रहे हैं तो अपने भाषण में यहां प्रधानमंत्री कह दें कि वो झूठ बोल रहे हैं. यहां पे अगर दम है तो यहां पे प्रधानमंत्री बोल दे कि ट्रंप झूठ बोल रहे हैं. If he has the courage, if he has the courage of Indira Gandhi, yes, let him say here, yes, let him say here, yes, that Donald Trump, you're a liar, yes, that you did not make a ceasefire and that we did not lose any planes. Let him say it here. Yes. If he has the courage. 50% भी है इंदिरा गांधी का तो यहां बोल दे. 50% होगा तो बोल देगा, बोल देंगे. सॉरी सर, एक साइड से 7th फ्लीट आ रही है, बोलने दीजिए सर. सर मजा आ रहा है.
ऐसा नहीं
सर. अभी तो मैंने ओपनिंग नहीं किया सर.
आपका समय
अभी तो मैं सेट हो रहा हूं.
समय आपका कम.
अभी सेट हो रहा हूं सर, थोड़ी ढील दीजिए. अगर दम है, अगर सचमुच में दम है तो आज शाम यहां प्रधानमंत्री को कह देना चाहिए डोनाल्ड ट्रंप इज अ लायर. झूठ बोल रहा है डोनाल्ड ट्रंप. सर, एक नई चीज चली है, एक नया शब्द चला है, न्यू नॉर्मल. कि न्यू नॉर्मल है. एक्सटर्नल अफेयर्स मिनिस्टर नहीं है बट वो यूज करते हैं. भाषण में उन्होंने कहा कि सारे के सारे देशों ने टेररिज्म को कंडेम किया है. एब्सोल्युटली 100% करेक्ट. मगर उन्होंने यह नहीं बताया कि पहलगाम के बाद एक भी देश ने पाकिस्तान को नहीं कंडेम किया है। Not a single country has condemned Pakistan. Everybody has condemned terrorism. What does it mean? That the world is equating us with Pakistan. Earlier, when the UPA government was there, it was very clear Pakistan is promoting terrorism. And they used to condemn Pakistan for promoting terrorism. Now, not a single country has condemned. Acha, very interesting, another fact. I mean, sometimes this external affairs minister amazes me. He says that now even defense minister, we have deterred Pakistan. Acha, you have deterred Pakistan? Fine. The man behind Pahalgam is a Pakistani general called General Munir, Chief of Army Staff. That man is having lunch with the President of the United States. He is sitting there. Our Prime Minister cannot go there. Mr. Trump is breaking all protocol, and he's inviting the man who has done terrorism in India to have lunch with him. Prime Minister hasn't said anything. Prime Minister has not said, how dare Mr. Trump invite Mr. Munir to his office.
माननीय सदस्य इसको माननीय सदस्य
Now let me say what Donald Trump has to say.
माननीय सदस्य ये सदन
let me say what Donald Trump has to say.
सदस्य ये सदन की संपत्ति है,
Sorry,
इसको
sir.
मत तोड़ो।
Sorry sir, गलती हो गई। Now we have, according to this government, they have deterred Pakistan, and the mastermind of the whole operation is having lunch with the president. Mastermind. After that, the President of the United States says, reason I had him here was I wanted to thank him. I wanted to thank him for what? I wanted to thank him for not going into the war and ending it. Let me repeat it. The reason I had him here for lunch was I wanted to thank him, the man who carried out Pahalgam. I wanted to thank him for not going into the war and ending it.
Very shame.
Now, currently, General Munir, US General Michael Kurilla, head of their command structure, and generals from 4 Central Asian countries right now are having a conference on how to prevent terrorism. Right now. So while these people are running around telling the world that Pakistan has done terrorism, the United States is having lunch with the man and organizing and trying to figure out how he can help them fight terrorism. I mean, which planet is the foreign minister sitting on? Like, please come down. I don't know where you are. Come down. You have flown off somewhere. Right? The second thing, new normal. New normal is the chief architect of Pahalgam is having lunch with the President of the United States. New normal. Now there's another new normal. There's another new normal. Fantastic idea. I don't know whose it was. At the end of the operation, by the way, the operation is still going on. They have declared victory, but it's still going on. Right? At the end of the exercise, they say, the government of India says, any act of terror is an act of war. Now, do you understand what this statement is saying? What this statement is saying is that any terrorist now who wants to make India fight a war has just got to do one attack in India. मतलब आपने पूरी की पूरी पावर आतंकवादियों को उठा के दे दी कि भैया आपको युद्ध चाहिए ना, आप एक अटैक कर दो, युद्ध हो जाएगा. It's craziness. You have taken the entire idea of deterrence and turned it upside down. Right? So today, no, one second, you're laughing. Tell me something. The next terror attack that happens, what will you do? What will you do? You'll attack Pakistan again. So now, the moment they know that you're going to attack Pakistan, they just have to do a terror attack and they know you're going. So, this government is clueless even about what deterrence means. Right? This government is clueless about what political will means. This government is clueless about what it means to let the army, air force, navy fight. That's the reality of the situation. Now, I said in this house, standing right here, about 3-4 months back, and they laughed at me. They laughed at me. I said that please understand that India's biggest foreign policy challenge has been to keep Pakistan and China separate. And I said here that I am sad to say that you have destroyed the single biggest, most important goal of Indian foreign policy. China and Pakistan are fused like this. Okay? Now let me tell you what that means. Well, let me tell you what that means. It means, sir, अगर आप समझना चाहते हैं मैं समझा दूंगा थोड़ी देर बाद. Please. समझा दूंगा सर. Please आप समझा दूंगा तो बैठ जाएंगे सर. Don't worry, I am ready to do it. What happened actually, the truth of what happened, because I have to say that. What happened is that the government of India thought they were fighting Pakistan. And when they arrived, they suddenly realized that they were not fighting Pakistan, they were fighting China and Pakistan. Yes. Meaning that the Pakistani army was attached. Pakistani Air Force was attached to the Chinese Air Force. And not only that, the doctrine of the Pakistani Air Force was completely changed. The information available to the Pakistani Air Force was completely changed. And the Chinese were feeding information, critical battlefield information, satellite information, targeting information to the Pakistanis. And if you don't believe me, one second. If you don't believe me, General Rahul Singh, during a FICCI event, May 11th, when the DGMO level talks were going on, Pakistan actually was mentioning, we know that you such and such important vector is primed and ready for action. I would request you to perhaps pull it back. And he says, so it is very clear they were getting live battlefield inputs from China. If you had listened to me here, you would not have lost those 5 planes. If you had listened to me and you had said that yes, the Chinese and the Pakistanis are fused, sir, EM, External Affairs Minister says, yesterday in his speech, he says, the two-front war concept is a very old concept. I don't know what he's talking about. The two-front war concept is gone. It doesn't exist anymore. There is now a unified front concept where there is only one unified single front, and war is going to be held on multiple domains: space, electromagnetic, cyber, undersea, air, space, air, land, sea. So he does not even understand the basics of warfare. He's talking about two front. That ship has sailed long ago. Speaker, sir, how did this integration between Pakistan and China take place? I want to make it clear. There is a center called CENTIAC, Center for AI and Computing, that was built in Pakistan with Chinese help. that was built in Pakistan with Chinese help. And the aim of the center is to integrate the Pakistani Air Force with the Chinese Air Force and make and transform the Pakistani Air Force into a network-centric Air Force. Speaker, sir, as I speak, and since 2021, Pakistani officers, strategic officers have been embedded in the PLA's Western and Northern Theatre Commands. They are sitting there, coordinating. So it is important to understand that you did not have political will, that you did not give freedom of maneuver, but there is another problem. And the problem is that we are now facing not just China, not just Pakistan, but China and Pakistan fused as one militarily. Speaker, sir, it is dangerous in this time for the Prime Minister to use the forces to protect his image. It is dangerous for the country. The forces should only be used in national interest. The forces should be used with freedom. If you want them to be used, you want to unleash a tiger, free him. Do not tie his hands behind his back. Do not go to the Pakistanis and say, listen, don't escalate. Then go all the way. Then fight properly and defeat them once and for all. Don't have President Trump tell you that I have stopped the war 29 times. Have the courage to tell him, no, to hell with you. You can't stop any war. We're going to fight. Speaker, sir, there is also I don't mean to keep mentioning External Affairs Minister, but it comes up because he's central to this discussion. I want to finish by telling you about something he said that shows the complete bankruptcy of the foreign policy of this government. Please remember that not a single neighboring country, not a single country condemned Pakistan. Not one. They condemned terrorism, they didn't condemn Pakistan. This is something that he didn't say. Now listen to what he has to say. And this shows you the mindset of these people. This explains why in his entire discussion yesterday of 1 hour, the defense minister did not say the word China. This explains it. And let me read the quote from the External Affairs Minister. Look, China, are the bigger economy. What am I going to do? As a smaller economy, am I going to pick a fight with the bigger economy? It is not a question of being reactionary. It is a question of common sense. Meaning he is scared. And this is the point. The point is that we are now facing in front of us Chinese and Pakistani fusion. And it is a very dangerous time. As you can see, it is a very dangerous time. And we cannot afford a Prime Minister who does not have the courage to use the army the way it has to be used. We cannot afford a Prime Minister who does not have the guts to say from here that Donald Trump is a liar. He didn't stop India from fighting. Okay. He's lying about the planes. Okay. We need a Prime Minister who completely frees the army, frees the Air Force, frees the Navy and says, go, khatam karo kaam ko, like Indira Gandhi did. Thank you, Speaker, sir. I'd like to end by saying this entire discussion is about the people who died in Pahalgam. It is a tragedy, and it was very disturbing to me, again yesterday, where they were talking about everything. They were talking about Pakistan, they were talking about everything, but they did not mention the people who died in Pahalgam. Okay. So let me finish.
Finishing. Otherwise, you are not allowing, sir, LOP. Only this time, only allowing.
Other time mic is not allowed.
Sir, do not allow India to be reduced to a battlefield where large powers are fighting. We have to navigate. We have to protect our interest. Second, to the Prime Minister, the nation is above your image, above your politics, and above your PR. The forces are above your PR, your image, and your politics. Have the humility to understand that. Have the dignity to understand that. And do not sacrifice the armed forces and national interest for your own petty political gains. Thank you, sir.
Rahul Gandhi ji amidst us, kindly take your seats. The program is about to begin very shortly. I request the delegates to kindly take your seats. मेरा अनुरोध है जितने भी लोग और वॉलंटियर्स हॉल के बीच में सभागार के बीच में खड़े हैं वो कृपया साइड में चले जाएं. I request all the volunteers and the delegates who are standing in the middle here to kindly move to the side. As we await the arrival of the Congress President, it's a warm welcome to each one of you here, each one who fights to defend the Constitution. I request the delegates to take their seats and to please free the pathways right here. मैं सम्मानित डेलीगेट्स और वॉलंटियर्स से रिक्वेस्ट करती हूं कि आप अगर बीच से हटकर साइड में चले जाइए. Please maintain discipline.